The first paragraph is Tommy's legal team's submissions. Second paragraph are their lordships' responses. The third paragraph is an additional comment from the justices on Geoffrey Marsden's disastrous presentation. And the fourth paragraph is the serious ass-whipping which they hand out to poor Geoffrey. So let's take a look and I'll comment on the notes as we go along. The appellant's complaints were that 1. The judge should not have proceeded as quickly as he did, initiating and completing proceedings that day. 2. No particulars of contempt were put to the appellant. And 3. Insufficient mitigation was put forward as a result of the haste. So, too quick, it wasn't explained properly to Tommy, and consequently he didn't have an opportunity to mount a decent defence. On the first point, too much haste, a central criticism advanced on behalf of the appellant, Tommy, of the proceedings in Leeds is that the judge was wrong to proceed to deal with the contempt as quickly as he did. We consider that there is merit in this point. In contrast to the procedure followed in Canterbury, the appellant at Leeds was commencing a term of imprisonment of 13 months within 5 hours of the conduct complained of. Such haste gave rise to a real risk that procedural safeguards would be overlooked, the nature of the contempt alleged would remain inadequately scrutinised, and that points of significant mitigation would be missed. Those risks materialised. In the summary notes, the court agrees that the judge should not have commenced the hearing of contempt proceeding that day. Once the appellant had removed the video from Facebook, which Tommy did, he removed it from Facebook, there was no longer sufficient urgency to justify immediate proceedings. In those circumstances, it would have been preferable to adjourn. So the justices are in agreement. 1 down, 2 to go. On the second one, that no particulars of the contempt were put to Tommy, i.e. it wasn't explained to him what it was he was supposed to be pleading guilty to. No particulars of the contempt were formulated or put to the appellant, which word-for-word agreement. Starts to get quite interesting here. There was muddle over the nature of the contempt being considered. In both the short explanation and the sentencing remarks, there was reference to matters that could not have been a breach of the Section 4.2 order. Section 4.2 is the gagging order. Thou shalt not report on Muslim gang rape trials. And I'll give you the highlights of the legislation here. Contemporary reports of proceedings, which is what Tommy was doing. In any such proceedings, the court may order that the publication of any report of the proceedings be postponed. And that means if the judge thinks there needs to be a gagging order, he gets his gagging order. But Justice Burnett said there was reference to matters that could not have been a breach of the gagging order and which, by extension, don't represent contempt. And they quote Marson here. Over a prolonged period, you are referring to this case, the previous case, and to the subsequent case, and the vast majority of what you were saying was reference to cases like this, to Asian men, to the grooming of 11-year-old girls, and the number of cases like this. No one could possibly conclude that that was likely to be anything other than highly prejudicial to the defendants in the present trial. If the jurors in my present trial get to know of this video, I will no doubt be faced with an application to discharge the jury. To which the judges said, in our judgment it is clear from the breadth of these remarks that the judge had regard to matters beyond the breach of the gagging order. His reference to a possible application to discharge the jury could not have stemmed from the appellant repeating anything the jury had heard in the course of the trial, but rather from other prejudicial matter. So Tommy said things that the jury were already aware of and therefore couldn't possibly cause a mistrial, because they weren't covered by the gagging order, because the jury was was already aware of them. And during the appeal, Justice Burnett raised the idea of things that Tommy was doing which weren't contempt. He raised, for example, the fact of him talking about the cost of these Muslim gang rape trials. If you look at my live feed, I remember it was at 6 minutes 38 seconds, you can look at that, where he talks about the cost to the public purse, and Justice Burnett was saying, apparently during the appeal, how are these contempt? They're nothing to do with the trial, therefore they can't be a breach of the gagging order. They don't relate to the trial. So you've got two things which don't relate to the gagging order. Both other things which Tommy was talking about which didn't relate to the trial, and things which the jury already knew, the names of the defendants, for example, and many other things. So there's two things there which aren't covered, which the gagging order don't cover. And this is what ultimately Tommy's lawyers, when it comes to the new hearing, will do. They're going to, as Justice Burnett basically started the ball rolling here, or in the appeal when he talked about the cost, and here they talked about things which the jury already knew as not being covered by the gagging order. They'll chip away bit by bit at all these things. The cost, if him talking about the cost isn't contempt, then his simple presence in the area of the court also isn't contempt. Other things like talking about the weather, or talking about past trials, or just giving opinions on this and that, also they will argue aren't about contempt. And what they will do, what Tommy's lawyers will do come the day, they'll try to chip away as much as they possibly can from the contempt charge, while the Crown Prosecution Service will do the opposite and will try to keep as much as they can as pertaining to contempt of court. But that's the way things are going to pan out, and already you can see the justices here are talking about that, saying that things don't relate to contempt, they don't relate to the gagging order when the jury already knows about them, a lot of which was what Tommy's live stream was about. Anyway, carrying on. The failure to follow Part 48 Criminal Procedure Rules was more than technical. There was no clarity about what the appellant was admitting to, or on what basis he was being sentenced. And here they quote Part 48 Criminal Procedures Act. At the hearing of an allegation under Rule 48.9, which is initial procedure on failure to comply with court order, etc., the court must A. ensure that the respondent understands, with help if necessary, what is alleged, B. explain what the procedure at the hearing will be, and C. ask whether the respondent admits to the conduct in question. So on number 2, no particulars of the contempt were put to the appellant, to Tommy, so he wasn't told what it was he was supposed to be pleading guilty to. Their lordships are in agreement. There was no clarity about what the appellant was admitting to, or on what basis he was being sentenced. So that's 2 down now and 1 to go. Can we go for a full house? So the third one was insufficient time for mitigation was availed to Tommy. He didn't have enough time to prepare a proper defence in the 2 minutes he was given. Finally, further difficulties arose from the limited opportunities the counsel had. The counsel in question was the bloke who Jackass Jeffrey appointed to defend, quote-unquote, Tommy back in May, to investigate mitigation, arguments put in Tommy's defence. There was little else that counsel could have done within the constraints under which he was working. Those constraints being, let's try and get this Robinson lad banged up as quickly as possible in 10 minutes, if possible. The level of detail which could be provided to the court was very limited, and there was no opportunity to obtain character references. A sense of proportion must be maintained. Where a custodial sentence of considerable length is being imposed, it should not usually occur so quickly after the conduct complained of, i.e., a sentence of immediate custody within 5 hours of the conduct taking place, which covers the insufficient time to mount a proper defence, but also returns to the first point: it was all just too damn quick. So that's 3 down, none to go. The justices agree on all the submissions from Tommy's legal team. But we're not done just yet, because they have some comments of their own to add in paragraph 3. The order at Crown Court was also erroneously drawn up to suggest the appellant had been convicted of a criminal offence rather than having been convicted of contempt of court. Errors like this have serious consequences on the classification of prisoners, resulting in the deprivation of privileges. So contempt of court can be criminal, but in Tommy's case it was civil. Civil contempt of court most often happens when someone fails to adhere to an order from the court. So this contempt was civil, not criminal, but Geoffrey Marson's framing of it made it appear criminal. So now back to the detailed report, where they are blisteringly critical of Jackass Geoffrey. As with Canterbury, the formal record of the contempt proceedings wrongly suggests that the appellant had been convicted of a criminal offence rather than found to have been in contempt of court. The order drawn by the court says on its face that it is an order for imprisonment made under the Criminal Justice Act 2003. The term of 13 months is described as a sentence, and the suspended order of committal made at Canterbury Crown Court is identified as a suspended sentence. None of this is correct for reasons we have already given. Although this is a matter of form capable of correction, it does have serious consequences. Such errors should not be allowed to occur again. Judges making findings of contempt and sentencing in consequence should check an order or record going out in the court's name for accuracy. Accordingly, the classification of the appellant as a convicted prisoner has had the effect of depriving him of privileges relating to visits by his doctor or dentist, the freedom to choose what clothes to wear, and the absence of restrictions on prison visits and the sending and receipt of letters. We have noted already that a person committed to prison for contempt is entitled to be released unconditionally after serving 1/2 of the term for which he was committed. A convicted prisoner, in contrast, will be subject to release on licence with the attendant risk of recall. So that is a huge slap on Geoffrey Marson on the part of the judges. These errors should not have been allowed to happen, they say. Many, many privileges, as listed above, were denied to Tommy as a consequence of erroneously listing him effectively as a criminal, as opposed to somebody who had been convicted on a civil matter of civil contempt of court. And finally, the finding of contempt in Leeds is quashed. The court remits the matter of alleged contempt at Leeds Crown Court to be heard again before a different judge. And 4 reasons are given in the detailed notes. 1. It was inappropriate to proceed immediately on the motion of the court to deal with the alleged contempt after immediate steps had been taken to remove the offending video from the internet. An adjournment was necessary to enable the matter to proceed on a fully informed basis. In any event, 2. The failure to comply with Part 48 of the rules resulted in there being no clear statement, orally or in writing, of the conduct said to compromise the contempt for contravening the gagging order in place. 3. It was unclear what conduct was said to compromise a breach of that order, and the appellant was sentenced on the basis of conduct which fell outside the scope of that order, and 4. The haste with which the contempt proceedings were conducted led to an inability of counsel to mitigate fully on the appellant's behalf. So what does that mean? Geoffrey Martin has been humiliated by Lord Chief Justice Ian Burnett and the entire the entire panel. They've said errors happened which have serious consequences and shouldn't have happened. Obviously he's going to go on having his swanky dinners in his Kensington penthouse, but he has been absolutely humiliated by this. I don't know, obviously, the extent of which there is actual physical communication between these people, but I would imagine he's been hauled over the coals as a consequence of this. This is probably the worst day of his career by a wide margin. I don't suppose it's career ending, but it's an extremely black mark on his work as a judge.